All right, we are now in U.S. government, session 22. We've been talking about the amendments to the Constitution, and for several weeks we've been working through the Bill of Rights, the first 10 amendments that were put in place. Before we're done, we'll walk through all 27 of those. These first 10, I'll remind you, were set specifically to guard and guarantee the rights of the average American citizen. They were not written to protect states or other entities from the federal government or within the federal government. These 10 amendments specifically apply between the federal government and the individual citizen. We've looked at 1 through 5. This session will start in number 6. Number 6 says this: in all criminal prosecutions, the accused shall enjoy the right of a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusations to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The Sixth Amendment is vitally important to the fair and just judicial system of our country. In England, and as well as many other countries, during the time of our founding fathers, the founding fathers writing the laws for a new United States. The laws that governed the process of judging guilt or innocence were many times at best crude or non-existent when it came to the idea of a trial or even justice. In many places, even today, the concept and context of a trial and justice hinge more on guilty until proven innocent than innocent proven guilty. The Sixth Amendment is set in place to provide several specific limits and practices by the judicial system, because when they began to write this, they had been under a judicial system through Great Britain that many times was not fair. You could be accused of a crime and were considered guilty until you could prove yourself innocent. You could be put in prison, and the time frame from the accusation to the trial could just drag on and drag on. And so one of the things they decided from the very beginning was that with this new government, there would be a set of specific things put in place. So we're going to walk through those today and try to figure out what some of the very basic things that you as a citizen have. Number one, the first states any accused of a crime has the right to a speedy and public trial. The judicial system can't hold secret or private hearings, nor can anyone be arrested and held indefinitely with a speedy trial. That means the timing of a public trial must be as soon as possible to guarantee a fair representation by both the defense and the accusing party. When you are arrested or an individual is arrested and brought into custody and charges are arraigned against you, it becomes paramount to have a trial as quick as possible. Now, that doesn't mean that there's a rush to justice. It means that everybody involved has time to prepare their case, to gather evidence, to secure witnesses, to get all the things they need, but it cannot just lag on and absolutely nothing be done. One of the things, this article that's there, and I'm not going to read all that, basically it says that when you get down to the context, again, this is federal to individual. The average time from the time the accusation is made till the time that the case is over is probably normally less than 365 days. Now, sometimes it's shorter than that, depending on what the charge is and how severe they are. Sometimes it's not uncommon. It says the model time frame, let me start over. Model time standards, felony disposition, misdemeanor depositions. 75% of those are within 90 days. And then it goes on for that. So anywhere from 3 months to a year is about how long it takes from the time that an individual is charged till that court case is settled again in the federal court. Now, one of the things that's happened is every state has written a set of laws. Most states will have incorporated into them the same kind of state laws that are in place. Again, we're not talking about state versus government, federal government, but individuals versus government, especially the federal government. The last paragraph says, the public trial means that there must be some setting in which witnesses are present to verify and to provide for accounting in the lawfulness of what goes on. Certain types of cases will provide different settings for access to trials. For example, if you go to a court in the county for a speeding ticket, you go before the judge. You have the right, as a citizen, to request a trial by jury. Most of the time, that's not what happens. Most of the time, again, if you know you've got a speeding ticket, there's evidence to present. You go in and plead guilty. Matter of fact, in these days, you don't even have to go in. You can just call the county courthouse, tell them that you're guilty. They'll send you an amount that you have to pay. You pay it, and you're done. However, from small claims court up to grand jury, there is the right to trial by jury. That means that a select group of people then, and we'll talk about that in just a minute, are the ones that judge your case, not a simple individual. In the world of today, with media, sometimes judges will allow cameras in, and sometimes they won't. Because who can attend a trial? Who can go to attend? Listen, there's trials and judgments going on every day in your local community, in Montgomery County, in Conroe, in Texas, the Supreme Court, all the in-between courts. Who can go to one of those? Who can attend a trial is also based on the setting and sometimes the case, because there are certain trials, because of whatever's going on, certain limitations are put in place for the safety of the people involved, for the sensitivity of the materials being expressed, and so some of those kinds of things are in place, but no trial can be held in secret. It has to be a public trial, and there has to be witnesses that are involved in that. Okay? From a response from the website, a web page hosted by AVVO to the question, who can attend a trial? As long as you are not a witness, you can attend the trial. If you are testifying, then you may be barred from the courtroom until you have finished testifying. This would be done to assure that your testimony is not influenced in any way by any other evidence presented during the trial. If you're going to be called into a trial, then more than likely you will not be able to attend the trial until that you're called upon to witness. Outside of that, hey, if you don't have anything to do and you want to go sit, you can go down and go sit in a district court, appellate court, whatever you want to do, if you need something to do and see what the cases look like. Okay. Now, the second facet, not only do you have the right to a speedy trial, but the second facet of this amendment states the accused has the right to a trial by jury. The goal of this idea was to take the power of justice out of the hands of a single individual and place it in the hands of a group of people who would determine the verdict. So, and rather than trusting the judgment of guilt or innocence to an individual, a trial by jury selects a group. That group then makes the judgment. He goes on to state that this group, called jurists, must be impartial. If an individual is called or summoned to jury duty, and at some point in time, every adult living in a county will be summoned to jury duty. The context of jury duty is that because the text is a jury, in our terms, it's called a jury of your peers. People are called in. What happens when you get there, and the notes say this, that you are then questioned, that they will call way more people in than they will need for the trial, or whatever case is out there. And they will start with both the defense and the prosecution asking questions of the jurist. And as those questions are answered, then the people will either be dismissed or they will be retained, ultimately getting down to the number that the jury would have on it. But every person on that jury has to be approved by both the defense team and the prosecuting team before they seat it. They have to make sure there's not bias and they're not slanted toward one way or the other. Another protection verified by this amendment is those selected have to be from the same, and it says state or district, as the trial takes place. That means that jurists who are summoned to a trial, and we live in Montgomery County, Texas, that those people come from Montgomery County. They're not trucked in or bussed in from Houston, Dallas, Austin, California, Arkansas. They have to be a jury of your peers, people in your local community. Now, that term is somewhat loosely identified in that they don't have to be the same color, they don't have to be the same age, they don't have to be the same religion, but just the people that are your neighbors who live in your community. By the way, none of those are professional. They're all people who just live in the community that answered the call, that were selected to be on the jury. These jurists must be made aware of the nature and cause of the accusations before being seated. Not only do you have to be approved, you have to understand and know what the case is about. There's a huge difference between serving on a jury for a robbery, in which that a certain amount of money was taken and there was no harm done to individuals, human beings, versus a trial in which that an individual is accused of murder. And so the selection process somewhat shifts in that, okay? The third thing, the third area of the fourth area is covered in this amendment promises during a trial the accused will be afforded to confront, quote unquote, or have access to the testimony of those presenting evidence, as well as being afforded the opportunity to provide his or her own witnesses. That means this, that if you're accused of a crime, before the trial starts, your defense attorney, your prosecuting attorney, has the opportunity to gather up and know the evidence that's there. You can't go to a case and suddenly out of nowhere, the attorney that's opposing you, whether it's defense or prosecution, brings in out of left field testimony, evidence that you've never seen. The only way that can be done is it has to be presented in a way that provides both sides with the opportunity to have access to that so they can prepare for it. It is possible for an individual to refuse assistance. Oh, I'm sorry, let me back up. No one goes through a trial without knowing what evidence is there to prove guilt or to prove innocence. And so that's the other protection. The fourth thing is no one can be forced to go into a court hearing without the privilege of counsel. That carries with it the ability to put in place professional assistance in building the responding case of evidence or refuting the evidence that's being presented. That's the job of attorneys or lawyers. Anyone going into a case, even misdemeanor case, has the right to legal representation. Now, many times, because the cost is so expensive, sometimes when those cases come, that an accused individual can ask for court-assisted counsel. And so at that point in time, every trial, every level of trial has people that are paid for by the legal system to be representation for those folks who can't afford it. You get legal help from those folks that can't afford, for those folks that can't afford the cost of that. Okay? Now, the truth is, you can waive that if you want to, and an individual can represent themselves in a court of law. Unless you are a trained lawyer, then know the law. I would suggest that you don't do that. But you can if you want to, and that does happen from time to time. Okay, that's the Sixth Amendment. It guarantees a lot about trial. Now, the Seventh Amendment simply says this: in suits of common law, where the value is conversely less. Wait a minute, let me start this over. I'm having a hard time reading this. In suits of common law, where the value in consideration shall exceed $20, the right to trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in any court of the United States than according to the rules of the common law. Now, what happened was the Sixth Amendment said, okay, this is criminal stuff. This deals with criminal actions, criminal accusations, but what about those civil cases? For example, things like murder, theft, car thieving, or carjacking, burglary, those kinds of things are criminal offenses. There are civil offenses, slander, divorce, all those kinds of situations that are not criminal, but they are civil, dealing with the civil law. In those days, it was called the common law. And so the Seventh Amendment takes the Sixth Amendment and expounds upon it in the fact that when you get to a civil case, it carries the fairness of a trial beyond that of the opinion of a single individual. The same thing in a common situation. This deals with common common law or civil law and not criminal law. Those are met in the Sixth Amendment. The jury trial, as stated in the Sixth Amendment, is given a clearer understanding of this amendment. Any civil case in which the crime is over $20. Now, time out. We're talking about, this was written in 1791. So when we get to the beginning of understanding, literally today, $20 is like going to a nice restaurant, eating your meal, and skipping out on it. That's $20. But let me give you the concept of the intent. Because in 1791, $20 was considered a large amount of money. The next sentence says this: according to inflation, $20 in 1791 is equivalent in purchasing power to about $640.09 today, an increase of $620.09 over 232 years. So the intent was, this is not to be frivolous, but when they civil case, a crime is committed that has a significant amount of value, something that we say would equate to $650. The dollar amount set in this amendment doesn't change, but the concept of the value indeed is greater than $20. The other statement is decisions made and accepted in a trial can't be challenged by another court. For example, in a civil case, a piece of evidence is admitted and it's goes through the process, and it turns out to be something that proves the case one way or the other. Another court can't come in and say, wait, they can't do that. The civil matter and decisions in a court cannot be overturned by some case beyond and not associated with that case. Now, the appeals process means that what the decision was in this court moves to this court. But it's not a different court, it's a continuation of the same case. This has to do with outside cases or outside courts coming in and trying to influence because they don't like the evidence that is presented. This doesn't hinder appeals, but that process is simply a continuation of that same process. Okay, that's the Sixth and Seventh. The Eighth Amendment says this. The Eighth Amendment says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. This may be an amendment that you've heard about in many ways. Many times in the sentencing phase, in the court system, this amendment, this part of the amendment is raised because of the punishment being dealt out. Again, punishment under a criminal case or a civil case is based upon a set of limits that are in place by the government. However, this amendment was seen as vital to the fair treatment of citizens charged with the crime. In many countries and prior to the U.S. Constitution, individuals would be arrested and held without being charged or presented to the court. With the concept of bail, those charged would be allowed to secure a release pending a trial. In our country, if you are accused of a crime, you're arrested, you go before an arraignment judge to determine if there's at least enough evidence to hold you. If there is, and they're going to charge you and hold you, then there is an option, it's called bail, for monies to be secured and put up to guarantee if you're released that you will come back. Now, there are crimes and there are times that because when the individual is arrested, it's understood if they're released from prison, they're not going to hang around. They're going to leave. or the crime was so horrific that if we let this person out, we take a chance on not being able to have them come trial. So bail is a context of that. Bail is a monetary amount held by the court as a security for the assurance the individual will return and be present at the trial. Today there are businesses that provide bail bonds for those being arrested. If your bail is set at a certain amount, and there's another line in these notes that say the average bail based upon the severity of the crime will run somewhere from $500 into the millions of dollars. An individual in Harris County that was convicted or charged with a criminal offense because of the severity and the past record of this, the bail was set at $3 million. And so that means this: if he wants to make bail, he has to have a security of $3 million that if he gets out, he will be there for court. Now, bail bonds companies say you have to pay 10% of the total bail. Your bail is $500. You go to a bail bondsman. You sign a contract. You put up $50. That bail bondsman will guarantee the other amount to the court, and the individual is released. If that individual does not show up for trial, then the bail bondsman hires someone to find those people, investigators, private detectives, and they secure them and bring them in, and bail then is revoked. The bail bondsman will file charges against the individual, and they will be back in prison and be forced to repay not only what was put up, but the fines and the fees that it took to get them back to court. And so the goal is to say you can get out of jail, but it's not a get out of jail free card. It means that there's a guarantee put up that you will be in court at the time that you're supposed to be. All right. The second thing in this, a bail bond shall not be required. The excessive bail shall not be required, nor excessive fines imposed. The second thing to this guarantees that any fine charged by a guilty sentence cannot be excessive to the civil standards and law of the land. That means this: if I'm a judge and I have two people standing before me, both charged and convicted of the same crime, that I can't go to one and say, okay, your fine is going to be $400, and say to the other one, your fine is going to be $25,000. Now, within the framework of saying that, every court has a range based upon the evidence, the circumstances, those kinds of things that can adjust what that fine is within the framework of that. But it can't be excessive. It can't be that I don't like you, you've been rude, we know you're guilty, there's no remorse, so you're going to have to pay $22 million versus the criminal who, in the same situation, paid $50. So that's the concept of excessive fines. The third one is that the third thing, and the one most people will be familiar with, is the use of cruel or unusual punishment. For a period of time, and that means, for example, waterboarding, which is a way to torture individuals to get them to share information that they have, has been deemed cruel and unusual punishment. For years, for hundreds of years, in the United States, hanging was considered the legal way to execute someone who had committed a crime and received the death penalty. Then the electric chair came up. There was firing squads. I think the last person to be executed in the United States by firing squad was in the 1970s. Gary, my goodness, I can't remember his last name. But today, matter of fact, for a while, the death penalty, because of the court cases, had been ruled cruel and unusual punishment, and no one could be executed. Since that time, that understanding and that ruling has been overturned by the higher courts, so that in many states, the death penalty is part of the process. In Texas, the death penalty is imposed many times every year on those who have been found guilty of the death sentence. So, but they can't take them and tie them to a tree and take a whip and beat them till they die. They can't peel their skin off. They can't burn them in the fire. That cruelty that's there. Today, for the most part, the penalty of execution is done by the injection of lethal drugs. That's strapped to a gurney. A set of drugs are ingested into their body that puts them to sleep, and then it also causes the heart to seize up and stop working, and they die. Okay. Amendment number 9 will be done shortly. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So here's what happened. We get down to the last one, next to the last one. This amendment is kind of a catch-all for the protection of the citizens of the United States. The Bill of Rights could not list all the rights of the citizens in this country. There's just too many rights. And so these amendments couldn't go through specifically and break all them down, or you'd have a whole book of those. So this enumeration or numbering of the basic rights could not limit or deny the constitutional rights of a citizen. Basically, here's what this says. Just because this right is not listed in the Bill of Rights means that another entity, a state, a county, a city, can overstep those rights and say, because it's not in the Bill of Rights, you don't get it. This was set to make sure future efforts to limit rights not listed in the Bill of Rights would not be successful. This amendment has stood the test of time and its intent. More than 2 centuries, 200 years after its ratification, the Ninth Amendment has yet to constitute the primary basis for a single court ruling. That means Supreme Court ruling. That means this, that in 200 plus years, 230 years, that no case has ever come to the Supreme Court using this Ninth Amendment as the basis for the judgment that was to be made. It guarantees you the rights that a citizen has, even if they're not in the Bill of Rights, okay? The last one, number 10. In the days of the Federalists and Anti-Federalists, remember in those colonial days, there were those that believed in a strong central government, that when the founding fathers developed the United States of America, they saw a very strong central government. The Anti-Federalists saw a smaller, less powerful federal government in which that the states bore the weight of power. In this amendment, the rights of states to control the laws and governing of their states were guaranteed unless specifically prohibited by this Constitution or other laws were to be protected and left to the states. If this Constitution did not specifically limit things, then the states themselves retained the power to take care of all the internal work. For example, that's why in some states you see a set of laws that are in place to govern the people. You can cross the state line and the laws in the next state are somewhat different. Now, the basic rights of citizens in both states are there, but the other parts of the law, the individual states retain the right. Now, there are cases in which an individual will challenge the state law based upon their interpretation of the federal law. However, over and over again in the past 100 years, the rights of states to operate have been challenged and overridden by federal mandates and laws. For example, in many ways, especially in the past 50 years, 100 years, the federal government has, in my opinion, simply disregarded the 10th Amendment and imposed federal laws on states that were not intended to have imposed upon them. To give you an example, again, please, I do not say I approve this, and the federal, let me not go there because I don't want to open a can of worms. I'm trying to give you an example. For an example, in the 70s, the oil crisis came. And as the oil crisis came, there was an oil shortage. Well, the federal government decided that the best way to preserve gas and energy and help the country get through that was to lower the speed limit. Because the slower the cars drove, the better mileage they got. And so they imposed on all the federal highways, the interstates. Now, you understand in Texas you have private streets, you have city streets, you have county roads, you have farm to market roads which are run by the state, you have federal state highways, and then you have what we would call the interstate systems, which is like in Texas, in Houston, that would be 45, that would be I-10. Someday 59 will be an interstate, but you also have things like 59 South, 59 North that are state highways. You have private toll roads in Houston, but in the midst of that, the federal government said this: we mandate that every state know that we've lowered the federal law of the speed limit on the interstates to 55. And if your federal government wants to continue to get funding from the federal government to help meet the needs of your transportation system, your state highways, your county highways, then you will also have to lower your speed limit to 55. Basically, they said you don't have to, but if you don't play by our rules, then you do not get the funding that you're dependent upon to keep your highway system. And so for several years, the speed limit on the interstate highways was 55. The state highway patrol, again, not a federal entity, a state entity, had to, because it became the law, had to enforce that on the highway systems. And so if you were going from, in those days we were living in East Texas, and we would go to West Texas to see our family, and a trip that had been 8 hours then became 10 plus hours simply because of the speed limits that were in place. But that's a concept and some of what shouldn't happen because of the state's rights. Okay? That finishes up this lesson. Next week we'll pick up with another session on the beginning parts of the remainder of the other 17 constitutional amendments. See you next week.